Calling our next case, People versus Nelson. This is a 15-minute mini oral argument on the application. Good morning.
Good morning.
Both have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of that time if we don't use it up.
I will try to reserve 3 minutes. I will try to track my time, which I've been historically terrible at, and I will waive my free fire zone. Mike Middlestad of the State Appellate Defender's Office on behalf of Mr. Nelson. With me at counsel's table is Kirsten Nunn, who is on brief and has put a lot of work into the case and is well familiar with the issue. Relatively new addition to the State Appellate Defender's Office. If it's all right with the court, I'd like to start with the prejudice issue, not because it's any less, the error below was any less egregious than the issue with regard to Sergeant Roth's testimony, but because I think it's an issue that has broader implications across an evidentiary spectrum. Quite frankly, too, it's an issue that I've seen a fair amount of repetition with in this Court of Appeals. And quite frankly, if we prevail on the prejudice with regard to Sergeant Ziegler, we prevail regardless of whether you agree with us on Sergeant Roth's testimony. To do a proper prejudice analysis under Carenas and Strickland usually requires more than what the Court of Appeals did here, which was essentially to black out the inadmissible lines of testimony from the transcripts and look at what was still visible on the transcript pages and filter what was still visible through the lens of a sufficiency analysis. Much more is required. The reviewing court has to do a qualitative analysis that looks to many things, one of which is whether the error had a tainting effect or affected the jury's view of the admissible evidence and the inferences to be drawn from the admissible evidence. That was not done here. That was not done here, and we're asking this court to issue further direction to the Court of Appeals and a course correction on that front. We're also asking the court to properly apply the prejudice analysis of Strickland and Carenas, and doing so, find that with or without Sergeant Roth's testimony included in the basket of errors, that there was reversible prejudice in this case. There's really 4 reasons why there was prejudicial error that occurred in this case. Number one, there were numerous instances of improper opinion testimony given, and really it was profuse, and it went to virtually every single judgment call the jury was required to make, including the inferences it was asked to draw and the credibility determinations it was asked to make.
Tell me how you differentiate Sergeant Roth's testimony here from People versus Daniel and People versus Thurmond, where those courts held that similar testimony is lay testimony because it's based on the officer's perceptions.
Well, I mean, in the existential sense, everything that a fact/expert witness talks about is going to be based on their perception. But the difference here is what the officer did was he told the jury what he perceived, and then he tapped into his expertise, which he had described for the jury in the foundational testimony that the prosecution had presented beforehand.
It's that extra step after.
It was that extra step. And really, lay testimony is there to sort of help the jury picture what's being described, put them in the shoes of the eyewitness to help them understand what they're talking about. In fact, Sergeant Roth's testimony that preceded the improper opinions, I think, is an illustration of that. She asked him, he testified that there was an hand-to-hand exchange. The prosecutor said, well, what do you mean by that? And he's like, well, like if I'm handing you something and you're handing me something back. That's acceptable lay testimony. But then the next step was, now go to your expertise. Go to the file in your brain, which is your training and experience, and tell the jury what your opinion of what happened is as an expert, not as an eyewitness, but as an expert. So really, it went much further than just simply painting the picture for the jury as it was telling the jury how it should decide the case, that this was a drug deal. The jury didn't really need to know an expert or anybody with training and experience that the relatively mundane act of handing somebody something on the street was criminal any more than the jury would need to know that anything else that happens every day in people's lives and that they see every day is different. That they didn't need an expert to tell them that this was not somebody handing somebody a piece of paper with directions on it or an address on it. This was somebody handing somebody drugs. There's nothing unique about drug dealing being hand to hand or anything like that. That's an everyday occurrence, and that's something that's within the realm of common knowledge. So it's expert testimony. It's also expert testimony that's improper to the same degree, although to lesser volume, I will admit, than Sergeant Ziegler's. But really what Sergeant Roth was telling the jury was, I've compiled this internal profile of what a drug deal looks like. I'm plugging these acts into my internal profile, and I'm matching up that profile with what I'm seeing, and I'm telling this jury that this is a drug deal. When the jury is in just as good a position to make a call on what happened based on all the evidence, the totality of the evidence, as the witness, the case law says that the person is not allowed to give an ultimate opinion on guilt, and that's what he did here. The elements of the crime were, was there a delivery? And he told the jury that this was essentially a delivery without any firsthand knowledge of what was going on between these two. So that's the difference there. With regard to prejudice, like I said, the improper testimony was profuse, and it really did impact the key, number one, the credibility call that the jury was required to make. Mr. Nelson testified and said that this was just an innocent encounter where we talked about directions. Mr. Blount testified that this was a drug deal. Notably, the jury was instructed that in assessing a witness's credibility, they should look to whether that testimony jives with other eyewitness testimony that was given. Well, what was some of the other eyewitness testimony that was given here? There were multiple times where a witness said that was a drug deal. So they were able to match that up with a person who was a professed expert, who they're normally, or typically the law recognizes they're going to defer to, they're going to defer their judgments to, telling them that this was a drug deal. This wasn't just an exchange of or somebody asking for a direction there. So when Mr. Blount took the stand and said that this is a drug deal, they had already been told by an expert that who had essentially diagnosed this as a drug deal without really seeing what was going on. So that had a pervasive effect on
Isn't the question whether they would reach that diagnosis on their own based on the proper evidence that was admitted and even the proper, I guess, testimony by the officer who was qualified as an expert?
Well, it's a much closer call, right? Because what you would have had the proper testimony been given, you would have had one witness saying it was a drug deal, who was subject to impeachment, who had a bias, who the jury could infer was a bias.
Had the experts say, my experience, people who drive evasively and who make frequent stops, may be engaging in drug activity, right? That's proper as long as it's not applied by the expert to this case, right?
Absolutely, absolutely.
And hand-to-hand activity at a vehicle window that may be indicative, et cetera. And then, of course, you have all those observations, firsthand observations of those things happening in this case. Even before you then have the person engaged in the drug transaction testifying that indeed.
But the step that is missing in that is the tie would have been an inference that the jury could have drawn, as opposed to what happened here, which an inference that the jury was told, as a matter of fact, had occurred. We had this officer not just telling them, this is consistent with my experience. We had an officer telling them this was counter surveillance techniques. Mr. Nelson,
the one officer, the one we were looking at, issue 1, his testimony was pretty minor, right?
His testimony was pretty minor, but it's a difference in degree, but not a difference in kind. It was clearly expert testimony, and it was clearly improper in that it invaded the province of the jury.
I don't disagree with you that officers should not have been permitted to testify. I can't find it, but really it just comes down to the last answer he gave.
Yeah, yep.
In that case, that by itself wouldn't be prejudicial, would it?
I think it would be, but remember, this court in assessing prejudice has to look at all the cumulative errors that have been identified. And you've got one instance where one officer who testifies as a quasi-expert that this was a crime, and then you've got another qualified expert saying at least 12 times that this man was a drug dealer, that this man had, in fact, he went into great detail. Mr. Nelson reached into his pocket, or Mr. Blount reached into his pocket, pulled out cash, handed it to Mr. Nelson. Mr. Nelson produced drugs and handed it back to Mr. Blount. It was that detailed, it was that vivid, without any firsthand knowledge whatsoever. And he was doing it through the filter of his expertise. Not only that, but he encapsulated all of Mr. Nelson's activity that day as that of a drug dealer. What is your opinion of what happened here, what Mr. Nelson was doing during this hour that you were watching? He was making a series of drug deliveries. He was using counter surveillance techniques, not that his conduct was consistent with counter surveillance techniques, but that his conduct was counter surveillance technique. Not that he was, going into a house that possibly could have been a drug house, but that he did go into that drug house, and inside, I know because I'm an expert, he went in there and sold drugs. That's what he told the jury. And then this stuff about the lookout. He talked to a guy on the street who happened to be nearby his encounter with Mr. Blount. That was him using a lookout. Not that that was kind of consistent with what I've seen street dealers do before, but that was in fact a lookout. Not anything about how it matched up or anything like that, but that in fact was Mr. Nelson working with a drug lookout person. So it was far more. He just ran roughshod over the limitations on proper profile testimony. He essentially, because there was no limitation from the judge on how the jury could consider this profile evidence, they're supposed to be told that it's only an interpretive aid. Well, I don't know how an instruction could have limited to the jury's consideration in this case when he went so far beyond what was acceptable in the drug profile testimony and essentially narrated for them through the lens of his expertise about what was going on. Because there was no limitations, because there was no delineation between the opinion testimony and the fact testimony, in fact, it was all kind of filtered through his expertise. It was almost like he was a doctor standing up there with an ultrasound talking the jury through his diagnosis of what happened in the case. Well, the difference is the doctor can point to specific undisputed scientific fact that person, suffered certain injuries. This expert was pointed to all pointed to issues that were for the jury to decide. Was this in fact a delivery of drugs? When there was no way to really diagnose that in the traditional sense, and he was filtering it through his aura of expertise when really that just went so far.
No one disputes that his testimony was improper. The question is, what happens in this case? Not permitted to testify that way.
What happened in this case?
A reasonable likelihood of a different outcome.
What happened in this case, if he was not able to testify, is that you would have background evidence about the common practices of drug dealers, how they drive and stuff like that. You would have Mr. Nelson explaining, no, this was me going to different locations because I had a kid in the car and we were trying to get my girlfriend to her hair appointment.
Not the most plausible explanation.
It's entirely plausible. If anybody who's a parent knows that a screaming kid in the back of his car is going to have times where you're going to have to stop and get them to calm down. That's not certainly, and it certainly isn't the Court of Appeals or the reviewing court.
Went to the hairdresser wasn't ready, and when he's got a reason for going in and out of all these places. That's
true. And it is the jury's exclusive duty to make that judgment call based on the credibility. Now let's look at Mr. Blount's testimony. Mr. Blount, as much as he tried to be coy, as much as he tried to dance around the issue, he had an incentive to favor the prosecution's story, right? He got favorable treatment here. Now let's look what else.
The cases are legion in which a witness who got a bargain testified on behalf of the prosecution. This is, that's not hardly a notable thing, is it?
No, it's not highly normal. But we are here to determine prejudice. We're not here to determine whether that was sufficient to convict. We're here to determine whether the errors that were occurred skewed the jury's view of his credibility. And
you started. Can you give me what you're saying is the untainted evidence that we should be looking at?
Well, the untainted evidence is the list of background profile, which the jury would have never been able to connect the dots, would have been left to connect the dots themselves. Right. We have Mr. Blount's
let me just be clear. You say they never would have been. You don't mean they never would have been able to connect the dots.
No, I'm sorry. No, that the that the jury would have been
left
allowed
to.
to without the assistance of a person telling them.
Yeah, and with the prosecutor's argument as well,
Yeah.
connecting it up, right?
Yeah. We would have Mr. Blount's testimony about what happened. Mr. Blount was impeached, number one, with his motive to fabricate, and there was a relative, not just a relative, there was a dearth of corroborating direct evidence. He indicated that he had a prior relationship with Mr. Nelson. There was no phone records to show that they had a prior relationship. The theory was that Mr. Nelson was delivering drugs throughout Battle Creek on this day. They stopped Mr. Nelson seconds after his encounter with Mr. Blount. There were no drugs, no cash, no ledgers, no other indicia of drug dealing found on him. Now, they did have an explanation for how that might match up with a typical drug dealer profile, but really, there was no the only direct evidence was Blount. Blount's credibility was subject to challenge, and it was the jury's exclusive function to determine whether it was Blount or Nelson who was telling the truth. The expert came in and said, Blount's telling the truth, and here's why. I saw that. I'm an expert. Trust me, that was a drug deal. And when you have jurors who oftentimes are reluctant to really make the call of who's lying, especially when it's a toss-up like this, they're going to listen to a police officer who can assure them that this person was in fact telling the truth when he said it was a drug deal. I'm an expert, trust me. Thank you.
Good morning, Your Honors. May it please the Court, Jennifer Rossi on behalf of the people, plaintiff appellee in this matter. The Court of Appeals majority did not err in concluding that the sergeant testimony, when looking at it as a whole, was not objectionable as it met the requirements for admissibility under MRE 701. However, should this court disagree, it should also consider that the testimony is subject to reasonable dispute as it has been. Therefore, it's not plain or obvious. In any event, as questioned by this court, the Court of Appeals did not err, including that error did not affect the outcome of the trial here, looking at the totality of the evidence and thoroughly at the record as it should. And finally, under Carinas, reversal is not warranted here where it is clear that a plain forfeited error did not result in the conviction of an actually innocent individual or seriously affect the fairness, integrity, or public reputation of the proceedings. Quickly to the second question. Here, the Court of Appeals majority also applied the proper test for prejudice under Strickland versus Washington to the facts of this case and reasonably concluded that it had not been shown that but for defense counsel's error, the result of the proceeding would have been different. The likelihood of a different result must be substantial, not just conceivable. And here, I submit that it was not substantial, that had counsel objected to Officer Ziegler's or Sergeant Ross' impermissible points of testimony, that it would have made a difference in the outcome of the trial, particularly when we look at all of the instructions the trial court gave as a whole, that the jury was indeed to make their own opinions on the facts, to judge credibility of the witnesses. Police officers' testimony was not to be considered any differently than any other witness. All of the instructions as a whole fairly protected the defendant's rights. And an objection from counsel in all substantial likelihood would not have changed the outcome of this trial. Where at sentencing, the trial judge remarked, the evidence of guilt was overwhelming. The person you actually sold the drugs to testified in court. The officers observed you and watched you for an extended period of time. There was significant evidence establishing guilt in this manner. The officers did surveil the defendant as to his movements and properly testified to the actions that the defendant made.
Counsel, I'd love to jump in. Obviously, we heard Mr. Middlestat take a very different viewpoint on the evidence, understandably. That's one of the reasons we're here. I mean, it seems we ended up with, I believe, a deadlock jury here, didn't we? There was a deadlock instruction, I think.
There was,
I mean, not in
yes.
the end, but a deadlock
Yes.
instruction, yeah.
Yes.
So, I mean, obviously, I mean, we don't know why they were, having trouble, but we know we have Mr. Blount's testimony, which obviously Mr. Middlestat noted there were from his viewpoint, lots of challenges. And then we're left with, I think, just the police, correct? Is that a correct characterization of the
The
evidence?
police testimony, Mr. Blount's testimony, and the drugs themselves, yes. And the defendant's testimony as well, also acknowledging that he made all these stops. And yes, of course, he had a different explanation for the stops, but he did not deny that he was driving and that he made the stops and went to all the locations that aligned with the officer's testimony of what they saw him do that day. Mr. Blount's testimony was for the jury to determine his credibility. He very candidly said, yes, I was, the matter that I was part of has been resolved. I was initially charged with a felony. I pled to a misdemeanor. He was very candid about that. The jury had that information to determine his credibility. I do believe also that the Attorney General's amicus brief points that these are issues that frequently come up in criminal appellate law, and it would be helpful for this court to further explain beyond Randolph the difference and indeed the similarity between the prejudice tests and how courts should engage in a fact-intensive and record-thorough review to determine what, if any, effect the error did have on this case, particularly here where we're talking about, as I've argued below, not just forfeited error, but trial counsel actually elicited testimony that is now being held to be objectionable. So when trial counsel makes active decisions, then later on appeal, they state those very reasons for relief being requested are actions that counsel took. This court should be very careful in reviewing these claims and look at what effect the error did have, if any. And I submit that the result in this case was the proper one, and this court should affirm the Court of Appeals opinion below. With that, I will waive the rest of my time for any questions the court might have for me.
Any questions? Thank you both. The case will be submitted. And the court will be in recess until 11:30.